Thank you, Your Honor. We are here today in 4 separate cases entitled State of Ohio versus Crystal Facemeyer. Those case numbers being 19 CR 001297, 20 CR 000065, 24 CR 001178, and 25 CR 000368. Defendant is present in open court today with her counsel, Eric Cherry. Your Honor, we're here today on probation violations on the 2019, 2020, and 2024 case. The defendant previously waived probable cause, states understanding that today she will waive final hearing and plead guilty to the violations and proceed to sentencing. We're also here for sentencing on the 2025 case where she pled guilty by way of information on May 7th of 2025 to 1 count of theft of drugs, a felony of the 3rd degree, and 1 count of theft, a felony of the 5th degree. At that time, an updated pre-sentence report and victim impact statements were ordered. It's the state's understanding the updated pre-sentence report was completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Upon the conclusion of the final hearing waiver.
My notes indicate that on the is this a PD on the 24 case also? No.
That is my understanding, Your
Yes.
Honor. Yes, it's on the 19, 20, and 24.
Is the 19 and 20, she waived the final hearing back on January 8th on both those cases when she was sentenced on the
That's correct.
24 case. Is there a violation on the 24 case?
I believe a violation was done in all of them. A warrant was only done in the 20 case. There's
No,
no
no.
warrants on the others.
Okay, but she was sentenced on the 24 case on January 8th, at which time the final was waived on the 19 case and the 20 case. But in the 25 case, is there another probation violation on the 24 case? On the 24 case, did you violate her for the new
For
case?
this, yes, she should be violated in all
Okay.
3 cases for this.
Your Honor, this is the January 8th one you were talking about is a prior probation violation. This one was filed March 19th of 2025.
Yeah, that's what I was asking, because of the conviction in the 24 case, right?
The violations?
The violation in the 25 case, is it because of the conviction in the sentencing in the 24 case?
There is no violation in the 2025 case because that's just a
Okay.
sentencing. But it is one of the bases for the violations in the 24, 2020, and 2019.
All right, so she's already pled guilty in the 19 and the 20.
That's from a prior probation violation.
All right, I'm not even gonna monkey around with that, okay? We're going forward on the 25 case. Is there a violation filed in the 24 case?
Yes.
What's the violation?
The violation in the 24 case is 1, 2, 3, 4 violations of Rule 1.
What's Rule 1? Don't give me these rule numbers, just give me what the violations
all
are.
local, state, and federal laws, so it's all of the new charges.
I know, for what charge? For the 25 case?
Yes. So for the original charges stemming out of Willoughby Municipal Court, 25 CRA.
So you have a violation in the 24 case for the criminal nature of the 25
Correct.
case. Okay, that's all I'm doing.
There's one other additional violation.
I don't care about that. I don't care, okay? We can sit here all afternoon and go through all these things if we want, or we can get on with the business. So in the 24 case, there's a violation for criminal activity that resulted in the 25 case. Is that correct, Mr. Cherry?
That is correct, Your Honor.
How does she want to proceed on that?
Your Honor, I've had an opportunity to discuss this with my client, and we're prepared to waive final hearing and enter admission at this time.
Is that what you want to do, Ms. Facemeyer?
Yes, Your Honor.
So on the 24 case, what is your plea to the violations which came as a result of the criminal activity in the 25 case?
Guilty, Your Honor.
All right, I'll accept your guilty plea and find you guilty. Now, let's go forward on the sentencing on the 3 probation violations and the 25 case. Mr. Cherry?
Thank you, Your Honor. Your Honor, this is definitely not how I was envisioning being in front of you next time on this case. As I recall, and I'm disappointed even myself, that we left here on a positive note with an opportunity for treatment, and we're here back again on a new case, a new charge. All I can say is that I've been involved with people that have been recovering from addiction of various kinds and various stages for a long time now. And I've seen some people get it right away and work the program and become better and stable, and other people struggle over and over and over again. I've come to believe that relapse is part of the road sometimes of recovery. And it's an unfortunate unfortunate thing to understand for people who are outside, who don't experience what it's like to be subject to an addiction. Ms. Facemeyer has addressed and still struggles with, and will always struggle with, her substance addiction. Nevertheless, she had largely been in remission prior to maybe what happened when she was taken into jail with positive. Beyond that, she had 3.5 years after you put her out on judicial release before she got back in the system. She has been able to put together a long period of sober time. This addiction is a replacement addiction. It's the same thing that happens in your brain, no matter what your drug or activity of choice is. It triggers your endorphins, makes you excited. Your reward center lights up. That has now happened for Crystal Facemeyer with gambling, what used to be for drugs. It's nothing different. It's just a new flavor of the same problem she's had. And I know you've worked with her for a long time and given her plenty of treatment opportunities. I would just ask this court to consider NeoCap again. The last time she was there was in 2016. NeoCap is a program that is designed to address criminal behaviors and is a program that can handle a gambling addiction along with whatever might remain of her drug addiction, and get her back on the path to where she is able to be honest with herself. One of the things that was mentioned by the prosecution in chambers is that her honesty is an issue. Well, of course it is. She's an addict. Addicts are by nature dishonest. They have to do whatever they can do to maintain their addictive lifestyle. I'm just asking you, whatever you do for her sentence, that you consider treatment to be a significant and primary part of it, so that we don't just throw Crystal Facemeyer away. We give her at least the tools available to her that she can recover. And I'm asking this court to issue a NeoCap order, the jail treatment program, and an opportunity to come back before you in, say, a year for a judicial release hearing and possible probation with IOP. Thank you.
Thank you. Ms. Facemeyer, what do you want to tell me?
Your Honor, I just want to take full responsibility for my actions this time. I understand I've been in front of you a lot of times, and this time, though, I stand before you just asking for a last chance at mercy, because I do finally have a life that you gave me when you gave me judicial release that I don't want to lose. I'm here because you granted me that chance to even go into treatment and save my life that first time, and I'm just asking for it one more time, Your Honor, please. Thank you.
Ms.
Your Honor,
Cutts?
I apologize, but I failed to ask you earlier. My client's boyfriend, Dan Blankshane, would like to be heard, and Pastor Rollins is here as well. You heard from them before.
Okay, just tell me, just state your name and tell me whatever it is you want me to know.
Your Honor, my name is Daniel, and I'm Crystal's boyfriend. I acknowledge the fact that her actions and her choices alone are the reason that we are here today. I met Crystal in the program of Alcoholics Anonymous several years ago. We were members of the same home group. We both held various service positions in the group. As I got to know her a little bit more, I learned about her struggles and her journey. I had the chance to hear her story at a meeting the first time that she gave it publicly, and it gave me a lot of hope at a time where I was dealing with a lot of personal issues. And it gave me that hope that if I kept applying myself and I kept applying the principles of the AA program, that I'd be able to overcome my circumstances and maintain my sobriety, which by God's grace I have for over 7 years. Since that time, Crystal and I have gotten to know each other very well. She came to live with me in January of 2024. We continue to attend AA meetings both together and separately. We attend St. John Nottingham Lutheran Church together nearly every Sunday. We pray together both in the morning and at night daily. Crystal has made my house feel like a home again. She's contributed more than just helping me by cooking, cleaning, and helping with bills. She's encouraged me when I've doubted. She supported me when work has been overwhelming, and she selflessly helped her 22-year-old nephew out with money for car repairs and helping him tie up loose ends, while she's received no emotional or financial support from her own mother or father or anyone else in her family. She's been a strength and supportive to my elderly parents, who themselves have significant medical issues, offering her knowledge and certain things dating back to her experience as a registered nurse. She's been a true blessing to me and for them. I love her beyond words because I can't put into words what her presence in my and my family's life has meant. I've done everything that I can to repay that kindness and support in spite of these present circumstances. That's why I stand here today asking you for your mercy. I know that Crystal has brought a great deal of hardship upon herself. I know that every avenue has been explored and tried. It has not all gone in vain. Though her progress has been slow and has not satisfied this court entirely to this point, I have seen growth. As a recovering alcoholic and addict myself, I know firsthand not only the potential for legal consequences for those who suffer from this disease and the choices that they make, but most frightening is the potential that any day, any time an alcoholic or addict of any sort of vice chooses to drink, to drug, or even something like gambling over sobriety, it could be their last. Crystal chose to accept treatment when it was ordered to her and abstained and remained free from the grips of drugs for over 5 years until these present circumstances. Each addict progresses at a different pace, and once we cross that line, everything has the potential to be just as dangerous and destructive regardless of the form that it comes in. Crystal has come to that same realization and asked me to begin looking for facilities that would accept her on an inpatient basis the same day that she was arrested. I firmly believe that she has finally reached bottom and is willing to address these demons fully once and for all, but she needs that opportunity and a little extra grace in order to be able to do it. I've made several calls and tried to find somewhere that would accept her on an inpatient basis for gambling, but there is none that has been available. She has had 2 assessments that were conducted, one by Lake Cuyahoga and one by the McIntyre Center in Cuyahoga County, and they are unable to accept her. However, there is Signature Health, which is where she receives her psychiatric help from, which does have a gambling-oriented IOP program, as well as individual gambling counselors licensed and certified in that area of recovery. Your Honor, I understand that punishment is part of justice, but I humbly believe that restorative justice should also include the restoration of the offender. Part of that restoration and recovery from addiction is establishing a relationship with a higher power, who Crystal and I both know as our Lord and Savior, Jesus Christ. Crystal is still a young woman who has shown potential in the past. She fell into a long, dark, and troublesome path and has struggled mightily to free herself, and it hasn't been for lack of effort. Addiction is a cunning, baffling, and powerful disease. It leads people like her and I and countless others down the road to ruin, but it doesn't have to be a death sentence for us. We do recover if we're willing and we're able, and when I see her, I see through the years of the struggles that she's endured, the look of defeat, the emotional toll it's taken on her. I see the woman who still has hope, who still is holding on to her faith, and who just needs a little bit of extra help so that she can live a full and productive life. One that can make us all proud. It's never too late while we're on this earth to make the changes that we want to make within ourselves. It is my prayer that you will consider this and that you will grant her that opportunity. Thank you.
Thank you.
Ronald Rollins, I'm associate pastor at St. John Nottingham, where both Crystal and Dan attend. I'm here to support her. As long as she's been incarcerated, I've continued to visit her and pray with her and to help her understand that she's not abandoned. My concern is that she feels alone. She knows that our Lord is with her, but this is a difficult time for her, I understand. But I'm here purely out of support for her and to seek the mercy of the court for her.
Thank you. Ms. Cutts?
Thank you, Your Honor. I won't go through every detail. I know this court is familiar with these cases, but I do feel I need to do a level of information for the record. So in this most recent case in 2025, defendant was going into people's cars that were in parking lots. She was checking which doors were open. When they were open, she was going in and taking anything out that, apparently to get money of some sort. She was at 2 different locations. on March 17th for the most recent case. One was a business. One of the employees, Tammy Orr, went out to her car early in the morning. Her items were, including her purse, were in there with her medications, her money for bills, and some shopping money. Then when she went back out around the lunchtime hour, she realized her purse was not there. It included IDs, credit cards, 4 prescription medications, and approximately $180 in cash. When I spoke with her, she indicated that once she found out and was able to see the video of a person going into her car, she felt very dirty and had to wash her car inside out. She felt very violated. She said she had $120 set aside for bills that she had looked through, and between $60 and $80 in cash for some shopping she was going to do. Mr. Butler was working, he's the other victim, his company, Multi-Flow Dispensers. He was at a location when he left his work vehicle unlocked as he was going in between the building. And his metal folder full of receipts was taken and a bag full of checks was taken. So they both had economic harm. We'll say that Mr. Butler did get all of the items back, but at the time he was concerned for his work aspects. Ms. Orr got everything back except for the cash. That's because when the police thankfully were able to locate the defendant quickly, most of the items were still in her possession. These new offenses were committed while she was on community control in the 3 other cases we've mentioned. In the 2019 case and the 2020 case, she was on judicial release, so she had previously been to prison. And then in the 2024 case, she was on probation. She does have a history of criminal convictions. The majority of them have gone through this court. So we have the 2016 case where she was convicted of 10 counts of illegal processing of drug documents found in the 4th degree and 10 counts of forgery found in the 5th degree. She was given treatment opportunities at that time, as been mentioned, NeoCap and as well as JTP and Oak House. She did have multiple probation violations in that case, which included testing positive, being discharged from aftercare, bringing in somebody else's urine. She was ordered to Oak House and opiate recovery program. Then she had new charges out of the Mentor Municipal Court, which later became her 2019 convictions for possession of drugs, a misdemeanor, and petty theft. When probation was trying to work with her for review hearings, she failed to appear. She didn't bring documents as requested, and then additional charges came through. And she also tested positive for fentanyl and opiates. She was then revoked and sent to prison. That prison sentence was completed prior to the judicial release. But in 2019, as I mentioned, she had the misdemeanor theft and possession of drugs. In 2020, she was convicted of trespass and habitation when a person is present or likely to be present, found in the 4th degree. Also in 2020, she had a separate case of burglary, a felony of the 3rd degree, and identity fraud, a felony of the 5th degree. In 2025, she has the theft, felony 4, and identity fraud, felony 5. So as we've discussed, she has probation violations pending in the 2019 case, which is the trespass and habitation, the 2020 case, which is the burglary and ID fraud, and the 2024 case, the theft and the ID fraud. She has had probation violations in those cases previously. So initially on the trespass and habitation, to the 2019 case and the 2020 case, she was given judicial release. She was initially sent to prison on those. She's given judicial release. Upon judicial release, she has had a probation violation in those cases and now is pending the second one. In the 2024 case, she was last before Your Honor for sentencing on January 8th of 2025. She was sentenced that day and given the opportunity to report on April 16th, and you would determine if you were going to vacate the jail time. But she committed the new case, the 2025 case, prior to that, so that hearing was vacated. So she has had a lot of opportunities with different treatment, different help, given opportunities with the probation violations. She has not responded favorably to previous sanctions. state is also concerned that she seems to be getting medications from multiple doctors when it seems unclear why there need to be multiple doctors. In the past, she has made some requests about her treatment, and she's been given opportunities to try and work in the way that she wished to. That has not seemed successful. So based on all of that, the state does not feel that she's amenable to community control and that prison is consistent. So at this time, we would ask the court to terminate community control in the 2019 case, the 2020 case, and the 2024 case. We would ask in the 2019 case to reimpose the prison term that she was initially given. She would have 180 days jail time credit, and then the prison would give her the credit for any prison term she has served. We'd also ask in the 2020 case to terminate her community control and reimpose the prison sentence. In that case, she would have 78 days credit, and then the prison would determine the prison credit. And then in 2024 case, we'd ask to terminate community control and sentence her to prison on the 2 F5s. In that case, she would have 1 day credit. And in the current sentence, case set for sentencing 25 CR 368, we would also ask for prison. She has 2 days credit that are specific to that. The probation violation times has some overlap of 22 days. Depending how this court, if you were to issue prison, we are asking that they be consecutive based on her criminal history and being on probation at the time of it occurring. Then she would not get those additional 22 because they are in the 2020 case. We would ask for restitution for Tammy Orr for $180, and that any of the restitution orders in the other cases remain, the ones that have not been completed. Thank you.
All right, I've reviewed the pre-sentence report and the record for the previous cases. I've considered what Ms. Facemeyer has had to say, what those in support have had to say, what counsel has had to say. I've considered all the provisions in 29, 29, 11, 12, and 13. So this, in our history together, this is case number 5. One of them is done, the 16 case. The others, you've been given opportunity after opportunity after opportunity for treatment. And then this last case doesn't involve something as damaging yet innocuous as failed drug test. It involves going into other people's property and stealing from them, taking the opportunity on numerous occasions and breaking into people's property. So based on the totality of the history here, I'm going to find you're no longer amenable to community control. On 25, 368, on count 1, I'm going to sentence you to 30 months in prison. On count 2, 12 months in prison with credit for 24 days, restitution to or in the amount of $180. On the 24 case, on count 1, I'm going to sentence you to 12 months in prison. Count 2, 12 months in prison, credit for 1 day. On the 20 case, I'm going to sentence you to a term of 18 months in prison with credit for 78 days. And on the 19 case, on count 1, 18 months in prison. Count 2, 12 months in prison. Each of the multiple counts in the 19 case, the 24 case, and the 25 case will be concurrent to each other, and each of the cases will be concurrent to one another. Costs are assessed on each of the individual cases. When you get out, you might be on post-release control for up to 2 years under the parole authority. If you are placed on post-release control, they will impose conditions upon you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation, a maximum of which is the greater of 12 months or the time left under post-release control. Is there anything further, Ms. Cutts?
Yes, Your Honor. Some of it may have been what I missed. The 2019 case, she was originally sentenced to 36 months on count one
Right.
and 6 months on count two, so that would need to be reimposed as it was.
All right, I'll give her 6 months on count two, 18 months on count one.
And with that, did you give credit in that case?
Yes, 180 days.
And in the 2020 case, you said 78
78.
credit.
Right.
And then, I apologize, I did not catch all of the concurrent versus if there were any consecutive.
There are none consecutive.
So within each case, they
They're
each run
concurrent.
concurrent and then concurrent.
Overall, they're concurrent, yes.
And the post-release control for the 2019 case would actually be more than the,
Is it 1 to 3?
yes.
Okay, so you will be on post-release control for at least a year, up to 3 years, with conditions, and the remainder of the recitation of the ramifications remain the same. Anything further?
I have a brief moment, Your Honor.
Okay.
I believe that's all, Your Honor.
Mr. Chair, anything further?
Just a couple of brief things. One, Your Honor, I know we filed a motion for the administration of the gabapentin, and I know that was denied. There is also an issue with Lamictal and Zoloft, as I understand it. My client isn't getting it as she's prescribed. Could that be addressed? It was my understanding that was brought up at the prior hearing, but I wasn't here. No?
It was not, I'm not.
No, it started to be brought up in chambers,
Mhm.
and you had indicated that you had dealt with that, and that it would have to come up later and.
All right,
but
so
you would ask
that,
for paperwork.
that motion was filed,
The
right?
gabapentin motion was filed,
Okay,
yes.
I'll have to take a look at it, because there are certain drugs they will not administer in the jail. Yeah.
Oh, I'll tell you, I found gabapentin on that list.
Okay,
I'm not gonna lie about it, but I filed the motion because she is prescribed it.
okay.
And I'm not sure about Lamictal or Zoloft, if they're
All
on
right.
the list or not.
I will take a look at the motion, because I know you filed it, but we didn't address it, so I'll have to take a look at it.
Was there a new motion filed? Because the first motion filed was denied.
Yes, that is correct. I could renew the motion with the additional drugs, just for your reference, do whatever you like.
All right, yeah, go ahead and do that.
Okay.
Okay.
And may I have a moment for her to execute a
Yep.
car title before she's taken?
Yep.
That's all. Thank you, Your Honor.
All